Good evening. Thanks for joining us. This is the last in the NACDL summer series, and this is a program on the willful blindness instruction, which has also been called many other things, including deliberate ignorance, the ostrich instruction. There's many different ways of naming the same thing, which is the instruction that deals with criminal cases where the government has to prove the knowledge element and yet has no evidence or insufficient evidence of actual knowledge. I'm joined tonight by a great panel of folks who have had real-time experience with these issues in cases over the last couple of years. To my direct left is Alex Walsh, who's a partner at Baker Botts. Alex has been at Baker Botts for 6 years, has tried some of the most interesting high-profile white-collar cases during that time, including the trial of Scooter Libby. She clerked for Justice Breyer on the Supreme Court, and then after clerking for Merrick Garland on the D.C. Circuit. To Alex's left is Dan Brown, who is a partner at Murphy and McGonigle here in D.C. Dan has been in private practice for about 10 years after spending 3 years at the SEC, and recently was involved in the appeal of the conviction of Mark Kaiser to the Second Circuit, one of the very rare cases in this area where a conviction has been overturned because of a faulty instruction, and Dan will share his experience in that case. And next to Dan is Casey Maxwell, who is the head of the law offices of Casey Maxwell. After working at Jones Day and O'Melveny in San Francisco, Casey also participated in the defense of Scooter Libby, and most recently was on the defense team for Frederick Burke, who was convicted of violations of the Foreign Corrupt Practices Act, in large part based on the instruction we're going to talk about tonight. So without further ado, I'm going to turn to the panel and have them discuss a little bit about the factual background of the cases that they were involved in to give you a sense of what the issues were as we start talking about the instruction.
Well, thanks, Andy, for having me, and thanks, everyone, for coming. I think it's a great topic and important for us all to be talking about it. The case that I was involved in is captioned United States versus Kang. It was in the District of South Carolina, and the trial took place this past winter. It was about a 2-month trial. The charge was conspiracy to commit mail and wire fraud and securities fraud, and the basic facts of the underlying substance of the charge was accounting fraud, that the executives of a company called Medical Manager, which by the time the case went to trial was a subsidiary of WebMD, had engaged in a massive 7-year accounting fraud that resulted in a series of misstatements to their SEC filings. The case resulted, unfortunately, in the 2 defendants who ultimately went to trial. The case started with 10 defendants. By the time we went to trial, there were 2. It resulted in a conviction. We have actually since had the conviction thrown out by the district court. He ruled in our favor on a Rule 29 motion, which actually had nothing to do with willful blindness issues. It's a statute of limitations issue, and the government now is deciding whether or not to appeal. Just some background facts about the case that are sort of relevant to the willful blindness issues and also to some of the materials that you have in your packets. The 2 guys who ended up going to trial were the president and the chief operating officer of this company. It was a small, before it was acquired and assimilated into WebMD, it was a small software company. The founder of the company had designed a physician practice management software tool that is probably in all of your doctor's offices. It takes care of patient information. It has a lot to do with the EMR, which is a big deal right now. Historically, the software had been sold by a sort of loosely affiliated network of independent dealers around the country. In 1997, the company went public, and part of its business plan was that they would raise capital to go out and acquire these independent dealers and create, sort of one vertical organization that designed and serviced the software and also sold it. They unfortunately, the guy they hired to run their mergers and acquisition program is a guy named Bobby Davids. And he pretty much operated on his own, going around and buying. A lot of these companies were like, $100,000 companies. I mean, small mom and pop shops. So he carried out this acquisition program, and as it turned out, in doing so, stole about, that we know, $8 million from the company. And he perpetrated this very sort of complex kickback scheme as part of the acquisition program. But there was accounting involved in it that in some cases did inure to the benefit of our client's company's bottom line. So after the company was acquired by WebMD, his fraud came to light, his kickback scheme came to light. He was fired. He was sued civilly by the company. The FBI came sniffing around, and he said, "It's true, I stole all this money, but let me tell you about all the accounting fraud that went on at this company." And he was the star witness of the case. A couple of his cohorts who had participated in his kickback scheme also became cooperators for the government. And I'll say that the theory and the message to the jury, both from the cooperators and from the government in their argument, was these guys, the defendants, knew about this fraud. They masterminded it. They directed it. They told us to go out, and carry it out, that we needed to make our numbers every single quarter. They knew exactly what was going on. They saw, the documents, which, if you knew what was going on, substantiated the fraud. So it was very much a case that was premised on the idea of actual knowledge, that the defendants had actual knowledge of the fraud. We never heard anything that suggested, argument or otherwise, that these guys looked the other way or sort of knew what was going on but didn't want to know. The first we started hearing about that was at the charge conference, when the government asked for a deliberate, for a willful blindness instruction. And, we argued vigorously against it, understanding the dynamic it would have in the jury room, but it was given. And as we'll talk about later, we were able to get some modifications to the instruction, which I think, could be helpful, but the jury did return 2 guilty verdicts. So.
Okay. My case was United States versus Kaiser. And just want to point one thing out. On the appeal, our lead counsel was Alexandra Shapiro, so I wasn't completely, and there were...
I was willfully blind at the end.
I've been with the case for a while, but there have been other smarter people than me who've been part of the history of it, and was certainly part of the success that we had on July 1st of this year. Just for those who may be watching on the web later, the citation is 609 F. 3rd 556, and again it's the Second Circuit from July 1st of this year. I guess it's in the materials as well. Our case, too, is an accounting fraud case. The company is called U.S. Food Services. They sell food and related products to restaurants. They're a distributor, essentially. One of the features of that business is that there's a substantial revenue or contribution to a company's bottom line profit through a form of rebate called promotional allowances, or PAs. They're managed, those deals, they're deals with vendors that supply the food, Heinz or whoever, and they're managed out of a department called the Purchasing Department. Mark Kaiser had been in charge of the Purchasing Department since from about 1994 until early 2001, but really had turned over day-to-day control in the mid to late 90s to the person who came to run the department on the org chart from 2001 through the revelation of problems in early 2003, a man named Tim Lee. The allegation was that the promotional allowances were inflated in order to allow the senior executives to hit bonuses. Tim Lee, like Alex's, I guess, case's chief cooperating witness, he had some other problems, too, that the government found out about it, and that made Tim a very willing cooperating witness. There was another cooperating witness, too, who was a man named Gordon Redgate, and the government's case was basically mostly those two fellows saying that they had various conversations and agreements with Mark to engage in this scheme to inflate the promotional allowances. It was, again, a direct evidence case. It wasn't about you know, they weren't offering evidence or theories or pushing, the government wasn't, the witnesses weren't saying, you know, this is a red flag kind of thing. It was very much, we agreed to do this. We knew it was wrong. Mark Kaiser told me it was wrong. That kind of stuff. At the charging conference, the judge, the government had not submitted their requested jury instructions yet, and the judge explained that he wasn't going to go through a written submissions and say, I'll give this one, I'll give that one, I'll modify it the other way. He said that's, you know, it's a waste of time. He would speak from notes and you know, give the well-settled elements of the crimes and would give some general instructions, and said he thought the case was appropriate for conscious avoidance. Of course, I should point out, our defense was elicited through cross-examinations, was that, you know, Mark wasn't in charge of the department when things seemed to really go off the tracks, when there was, you know, other people sort of noticed some problems. And he had participated in helping present the numbers to the auditors during the annual audits, but at the end of the year, having had nothing to do with running the department all year, and so was relying on Tim Lee and others to supply the numbers or the business volume, et cetera, that Mark, you know, used to calculate the results. So at the charge conference, the judge said, you know, I think this is a case where conscious avoidance is probably appropriate. We objected to it with the standard objection. This is not how the government put the case in. The judge said, you know, this is not in the indictment, this is not how they try the case, and the judge pointed out, probably accurately, conscious avoidance is never in the indictment. So that wasn't going to take us very far. And the government said, of course, we'll take it. And they submitted their instructions, including a conscious avoidance instruction that evening. In the Second Circuit, conscious avoidance instruction, it's very, I don't know that this makes it such an outlier from other circuits, but there are two provisos that any adequate conscious avoidance instruction has in the Second Circuit. It's the high probability proviso. The defendant must be aware of a high probability of the existence of the avoided fact or unlearned fact. And if the jury were to find that the defendant actually believed contrary to the bad fact, that would kill the conscious avoidance theory, and the jury couldn't find knowledge in that instance. So that's the actual belief and the high probability provisos. Our judge did not give those provisos, and in fact gave an instruction that that allowed for the jury to convict, in the Second Circuit so found, to convict on a theory of negligence. You know, he said that there are times a person can consciously avoid looking at facts that are available, and that in the law is the equivalent of knowledge. The judge sort of said it and resaid it a couple different ways, but the facts that are available sounds an awful lot like knowledge. And Mark was a senior executive of this company. There really wasn't a file cabinet in the building that he couldn't open and see. And so, you know, when Mark didn't know about certain contracts that had certain provisions, you know, sort of, well, he should have known, or, you know, he had available to him. He could have gone to wherever and said, you know, let's look at a file cabinet, or let me see this contract, etc. So, unfortunately, the judge gave that instruction, or maybe fortunately, the jury convicted, and the Second Circuit reversed because it did not, the instruction did not include either proviso. And this is a long-standing endeavor by the Second Circuit to get to ensure that adequate instructions are given, and even so much as 20 years so, this is 1988. In 1988, there was a case where the Second Circuit directed all the U.S. attorneys in the circuit to, in turn, distribute to all the assistant U.S. attorneys trying criminal cases a copy of that opinion. Basically, really put at their feet, you have the obligation to make sure the instruction is adequate, every bit as much as any defendant would. And so we, fortunately, continued that history, and the Second Circuit reversed, again, because because of the possibility of negligence. And I think the thing, I should also point out that the Second Circuit found that we didn't preserve our objection to the conscious avoidance instruction and applied plain error review, and still reversed, even though there was that higher burden for us. But I think what pushed them was that we had elicited substantial information, substantial testimony and evidence that it all came down to the two cooperating witnesses. And there was plenty of documented evidence that supported our theory as well, and it was a close case. And the jury could have sort of resolved the tie, if there were any in their discussions in the jury room, by the conscious avoidance instruction. It's sort of hard to argue with. Well, he's a senior executive, which is always a problem, and danger in these kinds of cases. Senior executives should do a better job. They're responsible, that kind of thing. But here specifically, the judge said if he had the information available to him, and during the forensic investigation, people found contracts that Mark didn't know about, et cetera, et cetera. So it's sort of hard for any juror to argue against that, I would imagine, or withstand much opposition from fellow jurors by pointing to that and making it hard. So that's about it.
Casey, you want to talk about Burke?
Our case is United States versus Burke, also in the Southern District of New York, for Judge Shinlin. And our client was charged with conspiracy to violate the Foreign Corrupt Practices Act. He was accused of conspiring to bribe Azeri officials along with Mr. Kozani and others in connection with an investment into the privatization of the state-owned oil company called SOCAR. He was the only person invested in that scheme who went to trial. And one of the key issues at trial was whether Mr. Burke actually knew that Mr. Kozani was bribing Azeri officials. And of course, like the other cases, the government argued, well, at least in our case, they argued the alternate theories, both theories during trial. But they did use cooperators to show that Mr. Kozani had, that Mr. Burke had actually knew about the bribes because the cooperators told him about them. And then in the alternative, they argued that he should have known because he could have done if he had done due diligence, then he would have figured out that there was bribes occurring with respect to his transaction. They exploited the potential of the conscious avoidance instruction, getting the jury to. You're making me nervous. Sure. The government exploited the likelihood that that the jury would find negligence by contrasting Burke's due diligence. They called his own lawyers. He had waived his attorney-client privilege, and so they called Burke's lawyers to show that he hadn't done the same amount of due diligence that another investor who decided not to invest had done. Mr. Klein here made a little bit of fun of the government for not being able to, in his closing, for not being able to choose which theory that they were going to rely on to prove Mr. Burke guilty. And in response to that, the government disavowed its reliance on the conscious avoidance theory in its rebuttal. In fact, he said, the government's proof is that he didn't look the other way. He was a detailed-oriented person who did everything he could to find out about the arrangement. He asked questions. He asked them again. Mr. Hempstead, his lawyer, testified that sometimes he asked the questions 3 times, and that's what he did here. And that's why he absolutely knew everything he needed to know to become a member of the charged conspiracy. And after that rebuttal, the defense obviously requested again that the conscious avoidance instruction not be given, which the judge promptly denied, and she gave it anyway. So Burke, not surprisingly, was convicted on the FCPA conspiracy, and it's on appeal now, and one of the issues is that there wasn't sufficient evidence that Mr. Burke deliberately avoided learning about the bribes, and also that the judge should not have allowed the other investor's lawyer to testify about his due diligence. I mean, Mr. Burke had never spoken to that lawyer, and he had no idea what due diligence that lawyer did or did not do.
So that gives you a snapshot of the three cases that these guys are going to be speaking on. And in a second, I'm going to have all three of them talk a little bit about how this instruction relates specifically to conspiracy cases, to securities fraud cases, and cases a little bit in the context of the FCPA, which is obviously an increasing area of criminal enforcement, and an area where the government's going to love over the next 10 years to talk about how anybody should have known what was going on when they were going to do oil business in West Africa, et cetera. But one of the things that I think is interesting about this instruction is how it has evolved historically and how unmoored it's become in some ways from its roots. If you start looking at the cases, a lot of this law traces back to a mid-70s case that came out of the Ninth Circuit called Jewel, which is interesting in a number of ways. One is it was a narcotics case. Essentially, the allegation was that Jewel drove a car with a secret compartment containing 100 pounds of marijuana over the border. And his defense was that he didn't know that there was marijuana in the car. And the evidence that came from his statements and other evidence was that he probably didn't know that there was marijuana in the car, but the circumstances by which he got the car, i.e. he met some guy who offered to sell him weed and then offered to pay him $100 to drive the car to California and leave it in an unmarked driveway, and he knew that there was a secret compartment, suggested quite strongly that what Mr. Jewell had done was sought to avoid prosecution by sticking his head in the sand and being able to plausibly say he didn't know what was in the car. The Ninth Circuit upheld his conviction in part on the grounds that in the old English common law there was a belief that essentially willfully blinding yourself made you as culpable as having actual knowledge of a crime. What is, I think, the most interesting about that case, to the extent that it was the jumping off point for this doctrine, is that there was a dissent written by then Judge Kennedy. And Kennedy's expressions of concern had mostly to do with scope and lack of definition. For, I think, a number of years, it was an instruction that was often used in narcotics cases that were similar in fact to Jewell, but it has grown, I think, exponentially over the last 10 years with increasing application in white-collar cases. And I think there are probably 20 cases a year now on this instruction because it is so frequently given. Later on in the program, I'm going to have some folks who thought they were just coming to listen to a panel. I'm going to enlist them to come up here and talk about a couple of recent cases where the instruction was given in cases where really the theory was, by all accounts, a should-have-known theory and has become more dangerous. Part of what's happened, I think, is that you see courts now, courts of appeals, having to deal with this instruction in a case where it has no place whatsoever. In your materials is a case out of the Fourth Circuit called Leidy, which is interesting in a couple of ways, in part because the Fourth Circuit says that the instruction shouldn't have been given, and there is good language in the case about the history of the instruction and why it doesn't fit. What's scary about the case is that it is an allegation of a street murder where guys put a guy up against a car, throw him in the trunk, take him to a deserted street, shoot him in the back of the head, and leave him in the car. Two snitches say, that guy did it. That guy says, I wasn't there. And the trial court gives a willful blindness instruction. Now, the fact that courts are willing to give these instructions in cases where I have not seen the discussion about jury instructions, but I have to imagine it was interesting to say the least, kind of shows where this instruction has gone. So we'll get back to that a little bit. But in the context of white-collar cases, I wanted to have these guys speak a little bit to the unique applications of the instructions and some of the issues that have come up in cases that are white-collar, not necessarily white-collar specific, but certainly white-collar repeating. So I wanted to have Alex start by talking about some of the unique issues that come up in the context of a conspiracy case, and I think did in South Carolina.
Yeah, sure. if you don't, I'll make a couple points about the history, because I really do think that the point you made, Andy, is important, that, the doctrine really exists for a very specific purpose, and to deal with, or, originated for a specific purpose, and to deal with a specific situation. In some of these Old English cases, the sort of prototypical case was an innkeeper who's at the front of the inn, and he has every reason to know that there's gambling going on in the back room, but he never goes and opens the door. And that's sort of the classic thing. Or these drug cases. I think the defendant in Jewel actually told the DEA agent, the reason I didn't open the secret compartment is because I was pretty sure there was pot in there, and if I got caught, I wanted to be able to say that I didn't know for sure. I mean, that statement was admitted in the trial. Like that, those are the circumstances where willful blindness is meant to apply, and the idea is, that is antisocial behavior that should be treated, as being equally culpable as knowing that the marijuana was there. That if the only reason you didn't commit a crime is because you said, I'm not opening that secret compartment, like, you shouldn't be let off and the other guy goes to jail. And as you said, I mean, it's now become completely unhinged from that that initial purpose. Another thing that's interesting about the Jewel case, and I just noticed this, is that the instruction that the Ninth Circuit upheld in that case is actually almost identical to the instruction that was given in your case. And Justice Kennedy's dissent says, I'll accept for sake of argument that this concept should exist in the criminal law, but if it's going to be given, it needs to stick to the definition of willful blindness, which is in the Model Penal Code, which says the person is aware of a high probability of the operative fact that makes this conduct a crime, and the person and you find that the person, notwithstanding that awareness, nonetheless actually believed that the fact wasn't present. So Justice Kennedy's jurisprudence on this has now started to has influenced the other courts. The issue we dealt with, that in some ways I found most interesting in our case, though it was an argument that was frankly a loser because it's sort of foreclosed in the case law, but I really struggled with the idea that deliberate ignorance could exist and be a sort of workable theory in a conspiracy case, because the whole notion of a conspiracy is that you're entering into an agreement, and how can you be willfully blind to the fact that you've entered into an agreement? I just told my colleague Rachel McKenzie here, I said, you've got to go find some case law that shows that I'm exactly right about that. We can argue it. And basically what the courts have done is sort of threaded the needle on that and said, well, there are actually two aspects to intent when it comes to conspiracy, and one is whether you're a knowing participant in the conspiracy. And with respect to that, willful blindness does not apply there. Like, it is true, you can't stumble into being a member of a conspiracy. You have to knowingly join the conspiracy. But in terms of proving that you knew the objects of the conspiracy, that's a separate element. In that, with respect to that element, the government can rely on a theory of willful blindness, that though you didn't actually know the aims of the conspiracy, the only reason is because you were willfully blind to what those aims were. So I think the courts are like, okay, we've cut this compromise position. I think that it makes absolutely no sense, because the concept of knowingly participating in an agreement, must have as an assumption that you know what the purposes of the agreement are. I mean, how can you knowingly join an agreement if you have no idea what the terms of the agreement are, what the objectives of the conspiracy are? So, it's an argument that I think people have a little bit given up on, making this argument that it just should have no application in conspiracy cases. I think that it should be reconsidered and should be pressed more heavily, particularly because it's not an issue that the Supreme Court has weighed in on. The Supreme Court has recognized the concept of willful blindness as being like a viable sort of knowledge substitute, but they have never opined one way or another on the instructions, what kind of instruction is proper, whether it needs to, follow the Model Penal Code as the Second Circuit does, and many of the other circuits do, and also has not, had occasion to grapple with this, can it apply in conspiracy cases.
Can you give these folks a sense of how the discussions on this issue went with the judge? Did you ever get to the point where you were getting much traction?
No, not on this particular issue. I mean, it's complete, it is, it's a foreclosed argument. I mean, it was an argument that we recognized, but it's foreclosed in the Fourth Circuit. I mean, it has been decided. And I think the traction that we did get is that, we pointed out that beyond not making logical sense, if you really think about it, it's the issue that deliberate ignorance can apply to one element of conspiracy but not another. The jury, particularly in a case such as this where there are debits and credits and 8 million transactions, and then you're telling them, well, there's this thing called deliberate ignorance, but it can apply here and not, the risk of juror confusion is obviously probably unmanageable. So what we were able to convince the judge to do was to make very clear and reiterate to the jury that in terms of whether these guys joined this conspiracy, they had to find that they were that they had actual knowledge. That Bobby Davids was going out and doing these things, and that they knowingly were part of that enterprise, his enterprise of fraud, and that they couldn't rely on sort of a theory of, well, they should have known or something in that context. So we did get some traction there.
One of the issues that we're going to discuss as the panel goes on, and that makes this instruction such a conundrum, is that in a lot of these kind of panels, we talk about, well, how do you set this issue up through cross-examination? How do you set this issue up better for appeal and closing? So many times what happens in these cases is that the deliberate ignorance instruction is sprung on you at the end of a case that's been all about actual knowledge, that it becomes very difficult to strategize how you would do things differently, right? If the government's cooperating witness is saying your client was in the conversation and understood the conspiracy, it's a little bit strange to start your cross with, well, my client never said, don't send me an email about this, right? I mean, it almost would appear to the jury that you're trying to avoid the question. So we'll talk about that as we go on. Dan, in securities fraud cases, one of the issues that we had discussed was the role of this instruction in the prosecution of cases that involve a higher scienter requirement. Can you talk to that issue a little bit?
Sure. Securities violations of the Securities Exchange Act are criminal when they're willful, and when the government proves they were done willfully, and then certain violations, books and records provisions, the government has to prove knowing and willful conduct. It's very confusing. The law in the Second Circuit until July 1st of this year seemed to be that that the government had to, but willful meant under the Securities Exchange Act was that the government had to prove that the defendant was aware of the illegality or that the conduct was going to violate the securities laws. Exchange Act maybe, or maybe just all the securities laws generally. Because that's the last they said of it in a case called United States versus Cassesi. In fact, Judge Calabresi, who was on our panel and was on the majority in Cassesi, expressed an opinion to the government lawyer during the oral argument that he was not too pleased with the way the government's brief seemed to indicate that that wasn't the law. So it was a little surprising in the opinion that came out for Kaiser that the Second Circuit panel said, including Judge Calabresi, it was unanimous opinion, unanimous decision, unanimous panel, said, but whatever we said in Cassesi about the other cases, it's over 30, 40 years of case law, we don't, the willfulness only means just a general awareness of wrongfulness. In one way, it's understandable because it's really hard to come up with an accounting fraud case which almost invariably involves some level of misrepresentation, inherently a misrepresentation, at least in the financial statements. But it's hard to say, well, there's a you could be lying about the results, but somehow it's you not know that it's illegal. I mean, you're a public company reporting results. It's hard really to come up with a plausible scenario where someone could be doing something that might generally be wrongful, but is different enough from what the violation would be that you could say, well, that wasn't willful. So you know, they don't explain why they back off. They just kind of do it. You know, another implication of this is the point, Alex, you were talking about with conspiracy, and does it ever make sense?
Right.
One can understand, and as Andy, you know, described the facts. You're getting a car from a guy, you're buying pot, you're driving it someplace weird and dropping it off and getting paid to do it. You know, so okay, that's sketchy from the get-go, possibly.
These are the views of the panel, not of the NAC.
Just possibly, I don't know. For sake of argument, I'm just going to say, for sake of argument. But my client went to a company that was a real company. They really sold food. The restaurants that bought from them sold food to people. You could go to restaurants. They had trucks that ran. They had warehouses full of food. You know, there's nothing inherently. He's going to work every day. It seems it's just like a normal company that does something. And you know, but at a certain point, that they're reporting their results and they're making representations to the financial statements or to the accountants, and that's illegal. Well, again, they have to talk to accountants. Companies have to book transactions, so you're not illegal until you know exactly what you did. It's wrong, or the wrongness of it. That's what makes it illegal. It's okay. So, conspiracy to commit securities fraud. You have to have a knowing agreement to violate. You know, one of the objects of the conspiracy, securities fraud, false books and records, false filings to the SEC, are the objects of our charged conspiracy. And it's really hard to separate those two out. Say, well, wait a minute, if you have to know you're engaged in an agreement to inflate the books and records, then, well, that's securities fraud, that's, again, false filings, etc. But you can't consciously avoid that knowledge. That has to be actual knowledge. Well, if they have the actual knowledge that they're agreeing to do that, and they do, you know, take steps in furtherance of it, they aid it, whatever. Then why is the jury? Why come back to okay? But now the substantive crime. Did he know that the results were wrong? Well, we just have to do conscious avoidance. It seems like if you answer it, if you have a real, distinction there, and you answer the question, the jury answers the question in the affirmative on the membership element of conspiracy, then who needs conscious avoidance for the objects? Okay, maybe a situation where you say, well, I knew two of the objects, but the other two I didn't actually know. It seems unlikely. And if that's truly the defense, I guess a court could give it. It would seem to make some sense in that instance. But I struggle with that, where there's even the government's charge of conspiracy and membership element of conspiracy in our case, is knowing and actual, and that's there's good Second Circuit case law that says you can't, through a conscious avoidance theory, join.
And I think part of the problem when the instruction is introduced into a case where it's really hard to make sense of it in light of the facts that have been presented is that the jury thinks, well, maybe there is sort of a negligence issue going on here, or maybe we are supposed to convict, based on, if we find that there's something like negligence or should have known, because why else would the judge be telling me this? It doesn't make sense in light of the facts, like the guy said, I purposely didn't look in that part of the trunk. I mean, why else is that instruction here? It almost invites them to convict on a negligence theory.
Right. And I just think it gets even more confusing if you have a willfulness that says that you have to prove an actual intent to violate the securities laws, because then I don't see how the conscious avoidance instruction fits within it. And I'm not saying this was the Second Circuit's goal in this, but it sort of makes it less confusing and contradictory and complicated. So to the extent that's a goal, I guess they furthered that. It's unfortunate, but so be it.
To the extent that this circuit started kind of walking away from some of this case law that had been developing over the 30 years, do you see a type of case that would bring the circuit back into engaging that issue in the securities fraud area?
It's hard to... You expect that the panel, when you say, yeah, but they have to prove violation of the securities laws, and they say, well, the conduct here was that, this involved a reporting that was important for a public company. U.S. Food Service was a subsidiary of another public company, but just for for sake of argument's sake, it's the reports of a public company. This guy's a senior executive, and he's saying things to the auditors who are auditing, and that's important to the investing public. And allegedly, my client was intentionally misstating facts. How can you? Where's the daylight between that being, a violation of this being securities fraud, and just being a non-securities fraud lie? It's really, really hard to formulate that. Now, they did say the cases that the Second Circuit said aren't like this one. They said, well, whatever we said in insider trading cases, so perhaps it's still in an insider trading case in the Second Circuit, you can still put the government or demand that the government prove that that the defendant knew he or she was violating the securities laws, but gee, we're talking about securities trading. So again, how do you say, no idea that those laws apply to this transaction? It's a stock transaction.
So, Casey, it sounds like you had the one case where the government was actually kind of talking conscious avoidance during the trial. And in a second, I'm going to ask you to tell folks about kind of what they tried to point to as evidence of that, especially in an FCPA case. But I want to follow up on the point that Dan was talking about with the Sienter and the securities fraud cases, because a couple days ago, the Third Circuit in a case called Stadtmauer applied this doctrine in a tax case. Dave DeBolt made the mistake of coming to a panel a couple of days later, and he has very nicely agreed to speak about that case to save me from the embarrassment of misstating what it was about. So Dave, if you don't mind giving folks a quick brief of what the case is about and how it folds into these issues. And Dave's got to come up to the microphones because we're webcasting this stuff.
Sure. Thanks, Andy. Yeah, our firm worked on the appeal for Mr. Stadtmauer. This was a case prosecuted in the District of New Jersey. It was about an 8-week-long tax trial involving false partnership tax returns. And our client signed all the tax returns as the number 2 guy in the company that basically ran hundreds of real estate partnerships. And the government's theory for the whole trial, they had 3 cooperating witnesses. Everybody else who had been charged pleaded guilty, and several of them testified, was that he knew what was going on in the company. He was intricately and intimately knowledgeable about all the facts about what was going on with these partnerships. And he knew that the internal books of the partnerships were not properly accounting for a number of expenditures. The case dealt primarily with whether certain things should have been reported as a capital improvement, or whether they could be expensed entirely in the first year in which the expenditure was made. And it basically involved this very blurry line between what is an expense that can be immediately deducted and what is a capital improvement. And there were other types of allegations as well about how the returns were false. So at the end of the trial, the government came up with its willful blindness instruction. And there was a big argument about whether it was even appropriate, since the government was arguing actual knowledge for the whole trial. And the judge agreed to give it, but he did agree to modify it because the government's proposed instruction said not just that he can be willfully blind, and that's how you can prove knowledge of a fact, but also that he could have been willfully blind of what the law required with respect to how these things should be reported on a tax return. And the judge ultimately agreed, but the government presented an alternative instruction in light of that, that still said that if he willfully blinded himself to the facts or circumstances that made the tax returns false or fraudulent, then you can find that he knowingly violated the law. And in fact, the instruction went further and said that the government can prove that he acted knowingly and willfully if he willfully blinded himself to these facts and circumstances. The Third Circuit agreed with us that that instruction meant that willful blindness as to what the law required would be sufficient to prove knowledge of the law, which under the Supreme Court's Cheek decision and other Supreme Court decisions dealing with tax violations made very clear that it's a specific intent crime where you have to show the person knew of the duty that they were violating, and that they did it with the specific intent to violate the law. Nonetheless, the court followed a couple of other circuits that have directly addressed the issue, saying that you can extend willful blindness not just to knowledge that you're relying on a false invoice to make a deduction on your tax return, but also that you're knowledgeable that even though the invoice is a legitimate one, that it should have been reported as not an expense, but as a capital improvement, and that you knew how the law applied to that transaction, even if you didn't really know what the law was with respect to that transaction. So the court, its decision came down last week. We're reviewing it, trying to figure out if there's something we can do with that particular issue for further review. But it was very frustrating to have a specific intent type case where the jury is told the defendant has to intend to violate the law, and they could substitute knowledge of the law, which he supposedly has the purpose of violating, with he just didn't do enough to figure out what the law was, and he kind of turned his head when the accountants were putting the tax returns in front of him, and he was signing them 300 or 400 at a time at a sitting. It was very frustrating in that respect.
Thank you. This is all about, opening up fresh wounds, this panel. So, and after Casey talks about the FCPA, I will tell you kind of why I'm moderating this panel, which is about a trial that I had in Ohio that turned on this instruction in another very strange way. But before we do that, so Casey, can you talk about kind of what the government pushed as their evidence of conscious avoidance, of willful blindness, and how you see that relating to kind of FCPA cases in a larger sense?
Well, in my opinion, I thought they were pretty blatant about arguing that Mr. Burke should have known that there were bribes going on. And one way that they did that was that they called an expert to talk about how Azerbaijan is a corrupt place. And that because it's a notoriously corrupt place, they used that fact to show that Burke was aware of a high probability that bribes were likely to have occurred in his transaction. So they took this, there's a general, assumption that there's a corrupt country, and said that because of that, then he should have known, because he was involved in a transaction in a corrupt country, he should have known that there was going to be corruption within the specific transaction that he was involved in. And that, I think they did that because they didn't have direct evidence that he turned a blind eye and said, I don't know about the bribes. And it seemed to work with the jury. After the case went to verdict, a reporter talked to the foreperson, and he said it was Kozani, it was Azerbaijan, it was a foreign country. We thought he knew and definitely could have known. He's an investor. It's his job to know. So it worked. I mean, just saying, it's... And the problem with that in FCPA cases that it's, as a matter of policy, it's a problem if you can find, if a jury can find conscious avoidance based on the fact that you're merely investing in a foreign country, that it's going to sort of squash any investment from the U.S. investors into those countries, like into Russia or other Russian or former Soviet Caucasus and South America, parts of Africa. So that's one of the ways they did. They also there were other ways that they. I'm sorry.
Oil executives across the world, I'm sure, are shuddering at the prospect of being held liable for willful blindness for investing in countries with a history of corruption.
Right.
It's an issue that if the government is allowed to put on this type of evidence in front of a jury, it is inviting exactly what courts say the instruction is not designed to do. This is a strange area of the law, because if you start doing research, the first, as Rachel Unker can tell you, the first days and days of research are very encouraging, because you find all these cases where every circuit has said, this is an incredibly dangerous instruction, this is given to misuse, this invites juries to convict on a negligence ground, and yet then all of the cases come out the wrong way. So it's a very strange juxtaposition, in part because I think the cases did start with cases like Jewel, where some guy's bouncing down the road in a jalopy with 100 pounds of marijuana in the trunk, and the Court of Appeals says, well, we're not going to let this guy off because some judge gave an instruction. The case that I tried in Ohio was on behalf of a guy who was an engineer at a nuclear power plant near Toledo that had been asked by the Nuclear Regulatory Commission for information about past plant inspections. And the plant submitted a number of formal submittals to the NRC that talked about how safe the plant was and how their prior inspections had been fairly good. And my client was involved in reviewing some of these documents before they went in. The NRC allowed the plant to stay open for an extra couple months, and then when they shut down, they found that there was a corrosion cavity growing through the head of the nuclear reactor that had gotten to about a 1/4 inch away from the through wall. At which point there were a number of folks that were indicted, and we tried the case to a jury of 12 people who lived within 15 miles of the nuclear power plant, who weren't particularly amused by these pictures and the repeated references to 3 Mile Island. There was ample evidence in the record that over the 18 months before the submittals were made, there had been emails going back and forth talking about cleanings, talking about inspections, and that my client as a manager had been CC'd on a number of them. The government's theory always was that he had gained actual knowledge of the problems with the cleanings and the inspections through these emails, and then at the end of the case, the court gave a willful blindness instruction in spite of the fact that there had been no evidence that the client had ever avoided conversations or sought to be taken off email chains, any of the things that would be the kind of core evidence of avoiding the gaining of knowledge. In fact, after the submissions had been made to the government, my client went and had 4 videotapes of the past inspection. He flew into DC and was told by his boss, "You need to take these videos and show them to the NRC." And he, saying that he didn't know what was on them, went and showed up, and the NRC had him put a couple of the tapes in. And it turns out that during the showing, he didn't actually end up showing all of the portions of the tape because he wasn't asked to. But it was one of these very strange cases where this guy, if he had actual knowledge, was incredibly willing to gamble his freedom by walking in with tapes that would have shown all of these statements to have been a lie. The instruction was given with all of the caveats that come with this. I mean, this was the standard Sixth Circuit instruction that said you can't convict on negligence, you can't convict based on you should have known. Mm-hmm. But the client had actually testified, and in my view was a credible witness. In fact, the jurors told us they believed him. They thought he was clearly competent. They thought he was a good engineer. He was obviously very responsible, and in fact, at the end of the day, his testimony may have been the strongest thing that convicted him, because there were a core group of 9 jurors who voted to convict on the willful blindness theory and said that he was just so responsible that he should have figured it all out. And part of what happened in our case was, and I'm going to ask Tim O'Toole to come talk about this in a second, because Tim had the pleasure of doing the appeal on a trial that I had lost, which he's done many times over the years. One of the issues in our case was that we were arguing this to the judge, and the judge essentially said to us, based on a Sixth Circuit case called Mari, that in his view it was a close call, but he was going to give it because the Sixth Circuit had already held that it was per se harmless error to give the instruction. So it was almost inconsequential. I don't think he quite said that word, but it was pretty close. I mean, we had a long discussion where the trial judge was talking about how this could be harmless error. So one of the issues that's developed in this jurisprudence is the courts of appeals have been so willing to kind of figure out ways to uphold convictions where most of the evidence was actual knowledge and the instruction probably shouldn't have been given, that there's become this perverse set of cases that give trial courts carte blanche to give this instruction even where they shouldn't. So this case has now gone through the Sixth Circuit and is well on its way to higher courts and greater things. But Tim, if you don't mind, I'd have you come up for a couple minutes and just talk about kind of the way that Mari has developed and the harmless error doctrine has developed, and what that means in these cases kind of going forward.
Well, Tim's come up, Andy, can I ask you one thing?
Absolutely.
Was there evidence that these emails that he was CC'd on, that he didn't open them, or?
No, and he never contested, that he must have read them if he had gotten them. There was never evidence that he had responded, or
Done it.
commented on them or done anything about them. And in this case, it was one of these cases where the government kept on saying, look, this shows he had knowledge, this shows that he had knowledge. What it really showed was that he had been exposed to facts. But in order to really know that the statements that were in the submissions were false, somebody really had to put together facts 1 through 8 and realize that those added up meant that this statement couldn't actually be true. And that really never got to the jury, in part because we didn't argue it in closing. I mean, the judge gave the instruction, unlike John, who apparently focused on it in closing. We just kind of were like, woo, we'll just argue actual knowledge. It wasn't until we were talking to the jurors afterwards and realized that, some of the jurors believed he had actual knowledge, but a great majority of them didn't. And the way that this jury had compromised was 3 people said, we'll convict on this grounds, and the other 9 said, well, we can come to a conviction on this willful blindness ground. So, and that's where Tim came into the picture, on the appeal.
That is where I came into the picture. So one of the things that makes cases like this one interesting is exactly what the panel has been talking about all along, and that is that they're really, when you go and look at the law, it developed from Jewell as to a kind of a paradigmatic set of facts for willful blindness in these drug courier cases. But since then, it's been applied, especially in the white-collar context, to a sets of facts where you can't really figure out a rhyme or reason other than the government really wanted a willful blindness instruction because their evidence of actual knowledge was weak, so they were scared they weren't going to get a conviction, and they thought maybe if they can argue willful blindness, the jury might think of it as a lesser standard and convict on that theory. And in the Geisen case with Andy, I mean, one of the willful blindness instruction, like a lot of these cases, it sounds like, came up at the last minute, so that it was one of these things where the government really raised it during jury instructions, probably as a result of the fact that during the trial, a lot of the cross-examination and a lot of the evidence that was presented really went to the issue of whether or not Dave had done a good job as a manager. There was this similar sort of evidence where they were comparing what a good manager had done with what Dave Geisen had done. And so you had this fact set when you got to jury instructions where it was pretty much undisputed that this guy did not do a great job as a manager. And so getting from not doing a very good job as a manager and missing things that you should have known that would have shown you that these prior cleanings of the nuclear power plant were pretty bad, because that was the topic of the interactions with the NRC, was how good were these prior cleanings that took place 6, 7, 8 years ago. A good manager, I think it was undisputed at the time of trial, probably would have figured this out. The problem was, and this was also undisputed in the case, Dave was doing, this was not a high priority at the time. I mean, in hindsight, it became a high priority because this hole in the power plant was discovered. But at the time, he was doing about 10 things, and this was one of them. He was a middle manager guy, and applying willful blindness to this set of facts was hard to understand if you look at it as a discrete, if you look at it as kind of the Claude Rains set of facts where you've got gambling going on in the back room and everybody knows it's going on there and everybody knows it's illegal, or you've got drugs in the car and everybody, anybody who was paying attention would have known that they were in the car and would have known that they were illegal. It's hard to figure out on this set of facts what Dave would have known that was actually illegal that was going on. I mean, yes, he could have known about the prior plant cleanings, but knowing about the prior plant cleanings was not, whether he knew about it or not, that wasn't going to implicate him in any sort of illegal conduct. So after we took this case to the Sixth Circuit and generated a quite terrible opinion, I mean, it's really probably one of the worst opinions on this that I've seen, because the Sixth Circuit found that you can give a willful blindness instruction on this set of facts, and the term they used was that he was willfully blind, or that he had consciously blinded himself to knowledge of the cleanings in connection with his interactions with a government agency. So basically, failing, and there was no evidence that he had said, I don't want to know that. No evidence that he had walled himself off and then walked into the agency. Basically, the evidence was that he didn't really know what he was supposed to know because he had gotten assigned this the day before when he had an interaction with a federal agency. So bad preparation with a federal agency, when you read this decision, can give a set of facts that can get you a willful blindness instruction, which is pretty scary. I mean, for anybody, and this is a heavily regulated industry where you have individuals who are going to have a lot of interactions with government officials, and so every time they don't do a good job and say something that they should have been more prepared for, this opinion gives the government license to get a willful blindness instruction in a false statements case, which is a pretty scary precedent. But what's more scary, and that's one of the issues that will probably be in the cert petition, because we think the problem with this, applying this to this set of facts, is the whole motive, and I don't think that's been talked about much here. But there's a line of cases on willful blindness that talks about this motive element, and the courts are split around the country about whether or not, when you make, if the government wants to show willful blindness, it doesn't just have to show that you consciously avoided knowledge, but you did it in order to escape prosecution. That was your motive. And the circuits are split on this. The Ninth Circuit just issued an en banc decision that was split 6-5 on this. We argued pretty hard in the Sixth Circuit that there was no way that the government could show motive on this set of facts, because avoiding knowledge of prior cleanings of the plant couldn't conceivably have been done in order to avoid knowledge of anything illegal. And the circuit gave us the back of the hand on that. They really didn't take it on. And so we think that that particular issue is one that's ripe for a cert petition and hopefully can get some attention from the court. It's also one that Justice Kennedy, was very hot on in the Ninth Circuit when he was there, with a number of dissents specifically on this motive issue. So that's one thing about the Geisen case and about the willful blindness thing that you should be aware of, is that the motive issue is one that I think might provide some sort of limiting principle so that you could have this instruction limited to a discrete set of facts. The other thing that Andy already talked about was this Mari rule out of the Sixth Circuit. And when I started doing this appeal, actually I started working on the case with Andy at the new trial motion stage. And Andy told me that the Sixth Circuit seems to have this rule that whenever you give a willful blindness instruction, as long as there's any evidence of actual knowledge in the case, that the willful blindness instruction is always harmless error. The Sixth Circuit had this rule. And when he told me about this, I thought, this is the craziest thing I've ever heard. I'm sure that can't be the rule. And then I went and read the case, and it really says that. And so, which made it hard for us, because we had a case where there wasn't admitted evidence of actual knowledge, but it really was either an actual knowledge case or nothing. I mean, the evidence of actual knowledge was slim, and one of the things Andy didn't mention, because he only usually talks about his losses and not his wins, is that another thing that makes this case extremely weird is that although Mr. Geisen has been convicted of making false statements to the Nuclear Regulatory Commission in a criminal trial, he's been acquitted by the Nuclear Regulatory Commission in a license revocation proceeding of making false statements. That is, they let him keep his license even though he's got the criminal conviction, because they found that willful blindness is not sufficient to show knowledge. And so they say, and they found no evidence of actual knowledge. So they actually had a trial with the same witnesses that were in front of the jury and acquitted him on a civil preponderance of the evidence standard. So you've got this scenario where you've got this guy who's been acquitted of knowledge, and that the trial judge agrees there's a willful blindness instruction that was given incorrectly, but then says it's always harmless error under Mari, and so he denies a new trial motion. The Sixth Circuit goes up and reaffirms this Mari rule and reaffirms it again in denying rehearing en banc. And so this other rule that's out there, that when I was doing the rehearing en banc petition was really surprised to learn, it's probably the majority rule. Most circuits follow this crazy rule that says if there's any evidence of actual knowledge in the case, not overwhelming or the normal harmless error test, but any evidence of actual knowledge, it's always harmless error to give a willful blindness instruction unless you've got a problem with the instruction itself. But if your only problem is there's no evidence of willful blindness, the courts assume that the jury convicted under the correct instruction, even in cases like Geisen and like some of these other cases where the real danger is that you've got a jury with all this evidence of what a good manager should have known or what a good executive should have known, and this instruction that seems to suggest that, even though it says don't convict on negligence, but what's a juror supposed to think? there's no negligence instruction, and you don't really want to ask for a whole set of instructions on what negligence is, so juries can figure out that this is not negligent. And so you've got this rule that really makes it, in the end, where courts have all this great cautionary language about how you should never give this instruction, but then they come back with, but if you give it and you're wrong in giving it, we'll never reverse you. So the incentives are all on the side of not giving the instruction. And that's really going to be the gist of the cert petition in Geisen. So if anybody is interested in writing the meat case, talk to me.
Following up on one of the points you made, and this is something Rachel and I were actually, she gave me this idea. One of the big problems with the Mari rule, and I don't know to what extent it's sort of an enshrined rule or just, the pattern in practice in other circuits that they just so constantly find harmless error, is that one of the best arguments for why you shouldn't have a willful blindness instruction is that this was a case about actual knowledge. To the extent there was any evidence of knowledge, it was evidence of actual knowledge, which is how you might win on, was the instruction given in error, but then you hung yourself on, that the error was harmless. I mean, so you really, to thread that needle is almost impossible.
Right. I mean, and that's even with the courts who are willing to apply a real harmless error standard. I mean, and that's the weird thing is that you have, I think, about 7 or 8 circuits who will say they follow the Mari rule, but then in those circuits, when they get a closed case, they actually go and do harmless error analysis, but then you run into exactly the problem that you just mentioned, is when they do the harmless error analysis, they take all this evidence that the government said was willful blindness evidence, and you've been arguing all along, but that's evidence of actual knowledge, and they take this and say, well, everybody admits all this evidence was evidence of actual knowledge, so there's a lot of actual knowledge.
I think one way of trying to get around it is to focus less on, there's evidence of actual knowledge and the cooperator said this, and to really focus on one of the, critical components historically of willful blindness is this evidence that, that you were confronted with some sign of, illegal activity and you turned, your eye to it. And so to not just look for, there's suspicious circumstances, but to really point to the fact that the record contains no evidence of the defendant receiving an email and saying, I'm not reading that email, or saying, I never go to the meetings about this subject because I don't want to know, because when this thing goes down, I want to be able to disclaim knowledge, or I'm not opening, again, in the Jewel case, there was direct evidence of, burying his head in the sand, and for the purpose of avoiding prosecution later, for that motive. And so to try to argue on appeal less about, all the government's witnesses said that I really knew, so the instruction wasn't proper for that reason, to really point to the lack of any evidence, of actually being an ostrich.
Yeah, no, that's right. One of the issues that Justice Kennedy raised in the mid-'70s in Jewel was this subjective versus objective test. That seems to me to be a relatively now settled position. And I wonder if you guys could talk a little bit about kind of what it means in terms of the subjective requirement, and Dan, whether that was something that came in. Your case turned on high probability and actually believing, but was there discussion about the subjective versus objective test?
There was no discussion about the subjective versus objective test at all. The only thing I was,
Go ahead.
The only thing I was going to point out is that during sentencing, because the government's service was that my client had actually started the conspiracy, was leading it. Again, why conscious avoidance, talking about direct knowledge. It was your idea. But you constantly avoided knowing what you were thinking. So, let's try to make some lemonade out of lemons and say there's no proper enhancement for being a leader, the leadership enhancement, because you gave the conscious avoidance instruction on. You must have believed that there was some doubt as to whether or not he led it. Maybe he sort of looked the other way about some things and went along with some stuff, but how could you be the leader at the same time? And the judge actually kind of, as I remember the tone, he said, look, I gave that instruction because you never know what the jury's going to do back in the jury room.
Like maybe.
But I heard all the evidence, and I think there was sufficient for I think if he wouldn't have needed it if he were the decision maker. So
And Dan is not exaggerating this. I mean, the transcript of this of the sentencing proceeding is in the materials. It is
it's
a stunning thing for a judge to say on some grounds.
they might screw it up and acquit the guy because they might. They might credit your theory, and I think, and maybe this might implicate the subjective objective, but I think this is the second part in the Second Circuit, that the actual belief that the bad fact isn't a bad fact, that the facts are otherwise. I mean, that's where it's a problem, because that was the core of our defense. Not only didn't Mark know, but it was different. The way he ran the department, what he did, the deals he negotiated, were different than what his successor did. So he had a real, actual basis, and his successor didn't tell him, although he said he did, but he had a lot of credibility problems as a Second Circuit member. So it really did sort of go right at the second piece. The Second Circuit didn't make a big point of that in their decision, but when you think about it, it's pretty damaging to that sort of affirmative defense kind of notion of your actual belief is otherwise, and so you give a watered down, insufficient conscious avoidance instruction because you don't want the jury to get distracted by, is it he didn't know because he didn't actually sign the contracts, or he didn't know because he didn't negotiate contracts that way, and when he asked anybody or talked to anybody about it, they never told him. It's sort of, I think it's importantly different.
Casey, did your judge grapple with this issue at all? I mean, it sounds like the government was putting on a lot of objective evidence of, anybody would have known given these facts about Azerbaijan. Did the judge even
Not
discuss
really.
that issue?
No, she didn't. She didn't, and she put off deciding whether she was going to give the conscious avoidance instruction until after the closings, but then she just gave it. So there wasn't really any doubt that she was going to.
And I do think that that's a continuing challenge that we face in terms of making strategic choices in these trials. In a case that's been so much about actual knowledge, how much of your time in closing or in cross-examinations do you divert to a secondary theory? Now, it turns out, in the case that Tim was describing, that we lost in Ohio, we really should have spent at least half the closing talking to the jury about what this willful blindness thing means, what it really looks like. I mean, what it really looks like is, you saying to a subordinate, stop sending me reports about the cleaning of the head, or, but because I don't think that juries really, they hear the instruction, but I'm not sure they really understand what this is supposed to look like. I'm not sure trial courts all understand what it's supposed to look like, so I'm not sure why we think juries would without kind of really hearing an analysis of it. But it's an interesting issue.
I don't think even if you spend half your closing talking about it, they still don't understand it, apparently. At least not in our case. They did.
You can prove willful blindness, not just, it doesn't, you don't need to use direct evidence. It doesn't have to be evidence that, Burke said, I am, aware of a high probability that there's corruption in this company. It's enough that if circumstances are such that the jury can infer that he was aware. And so what the government is doing is putting all those circumstances out there. But I think it again becomes very dangerous, that ability to rely on circumstantial evidence, because what that ends up looking like is that you're trying a negligence case. So, you put on an expert who talks about this is how you should have done due diligence, and that's permissible because, that means it allows for, it's sort of circumstantial evidence, like he was aware, or, this is how a due diligence should be conducted, and because he didn't, the jury can infer that he specifically chose not to, or, but at least one Fourth Circuit case that we came across talks about the fact that the reliance on circumstantial evidence in a willful blindness case is particularly dangerous, and that, courts should be careful about giving the instruction based on the existence of circumstantial evidence, because that heightens the risk that the jury will sort of revert to a negligence standard.
And one of the issues that I think will come up soon is the intertwining of the subjective standard and the inference. It has to be, to some degree, that the subjective test means that you can infer it, but you have to infer it from the defendant's behavior and actions.
Right.
Which brings you back to, right, objective things that the defendant does from which you can say that is evidence of what is pretty close to actual knowledge.
Right. Right.
And it'll be interesting to see. I'm going to ask these guys in the next 5 minutes to look into their crystal balls and give your predictions of where this is going in terms of arguments with appellate courts and whether this is an issue that gets to the Supreme Court and in what form. And I have not told them that I'm going to ask them this question. So this is like double jeopardy. Which also means that you don't have to have an answer, but if anybody has thoughts, that would be interesting. And then I'm going to ask for questions. So anything that's been bubbling up in your minds.
Well, I think I mean, you see out there increasingly, compelling and forceful arguments made about the danger of this instruction in white-collar cases and white-collar cases involving, complex, alleged, complex fraud schemes where you have a bunch of experts, particularly, I mean, think of it this way, in our case, we ended up not putting on a case, but it really was going to, in a lot of ways, could have boiled down to a battle of the experts. The government, had retained an expert who, 10 years later went back and did a, forensic examination and came up with a theory that this accounting was wrong and that, it was clear to her that it was wrong. And, and then we would put on our expert saying, well, here's why, it's not clearly wrong, or like, in fact, this is right. And in a case involving that kind of fact pattern, together with a willful blindness instruction, I mean, it really does look like a civil case, a civil negligence case. And so there's a great case, which I think we included in the instructions, called Hillard, in the materials from the 10th Circuit, that talks about the danger of the use of this kind of instruction in a case like that, where you have a bunch of experts and sort of after the fact analysis of these complex accounting or legal or due diligence issues. And I know the Counsel for Skilling did a I think impressive use of that case in their argument that the instruction had been given incorrectly. The Fifth Circuit in the end said, well, we're not going to decide if the instruction should or should not have been given, because it was harmless error. But I think that we're starting to learn from each other about arguing about the dangers of this instruction in this context, and how it really has gone so far afield of the historical roots of the doctrine and the purposes of the doctrine, that I think whether or not that gels into a nice question presented for a circuit split. I mean, I think that we're going to start to see more knock on wood victories in that area on appeal. That it just doesn't belong in the types of cases where we found it.
I would say it seems like it would be ripe for the Supreme Court to take up, and with some analysis say that justices who are considered conservative have a real problem with areas of the law like honest services fraud. It's so ambiguous and so hard for a law-abiding citizen to conform behavior to what the law expects if the law isn't clear. And I think you throw in, conscious of when it's willful blindness, it can, can come in and we can go with objective tests, and pretty soon, well, is there a legal requirement to do, what's the legally sufficient due diligence so I'm not a criminal? Well, nobody issued that report. Nobody gave anybody that checklist. And so it starts to sound like, it's just criminalizing after the fact. It's
right.
Looking back, finding an expert, say 10 years ago, it should have been different.
Mm-hmm.
You should have known.
Right.
So it seems like it's going to, it would fit within a vein of cases that have been positive from the defense perspective over the last few years, and with Kennedy on the court still, he's being important to him. You might be able to get at least the 4 votes to get started.
It'll be interesting. I mean, all right, if that happens, Skilling is going to be the leading case taught in law school for the next 50 years. There was a blog post a couple of weeks ago that was asking the question about whether willful blindness is the new honest services fraud, which I'm sure Shannon would be very happy about. It would keep the white-collar part of NACDL busy for many years. let me open the floor up to questions. So the question is essentially, how do you dealing with prosecutors on the issue of the potential for this type of theory to cause someone to be indicted in a case where there may not be evidence that this mid-level manager knew of the problems before something like that happened. Right. I'll open it up to you guys in a second, but let me just share kind of what my experience was based on our Ohio case, because it sounds very similar. I do think in a situation like this, if you're dealing with the government, it's a good opportunity to kind of talk about some of the things that Alex was talking about the roots of this instruction and the reasons that it should not apply. I mean, in some situations, it's probably easier to have that conversation now with prosecutors than it would be later with the jury. But I think, the more you can develop the lack of evidence that this manager was turning a blind eye to signs of potential peril, the better, right? You may all be able to agree that looking back with the benefit of hindsight, which is a powerful driver in these cases, there are things that should have been done differently, but in terms of a criminal prosecution, that really should never be the question. And to the extent that you can start focusing on what this instruction ought to look like, right? This is what the deliberate ignorance theory grew out of, and kind of focus on what the paradigm cases look like. It may give you the ability to say what I wish we had said to the jury, which is, these are the 5 kinds of things that would be deliberate ignorance, right? A report to the manager saying, the mine ventilation is insufficient, or the communication system in the event of an emergency doesn't work, or people are being exposed to levels of coal dust and danger that they shouldn't be. To the extent that those communications were not turned away by the individual, even if they existed, to the extent that you can distance him from where they are, I think it gives you the ability to talk about why this doesn't apply. And I do think this is a situation where kind of going back to the roots of the theory may be something that helps.
Yeah, but I mean, pointing out, the risk of doing this always is that you highlight for the government, the voids in the evidence and what they need to work on compiling. But one thing to do is to point out, where is the evidence of my client being confronted with him specifically. A document was shown to him that should have aroused his suspicions, and he said, I don't want to hear anymore. Where is the direct evidence that he turned a blind eye, to a fact that makes his conduct a crime, and this whole motive issue as well, and that the reason he turned the blind eye is not because it's 5 o'clock, I'm getting out of here, I have a softball game, but because he was like, because if this mine ever explodes, like I think it could, I don't want to be the one, under indictment. So to really point to the very specific, and there are 4 specific requirements for willful blindness, and can they find any evidence that fits within that rubric? And the fact is usually they can't. And another thing to do is if you have it, to point to evidence that's the opposite. I think because we all know at some level these cases, whether the instruction is given or not, the jury does often think of it in a negligence way. One of the things we brought out, didn't work, but these guys, they hired one of the best auditing firms in the world. They had auditors all over these transactions. They had lawyers. They had more and more reporting requirements as the company went on. Like this kind of behavior, like I want to know everything about the transaction. I want make sure the auditors are signed off on it. That is not consistent with someone who is acting with willful blindness. So if you have evidence like that, that he was proactive in terms of making sure that he knew what was going on and that he was discharging his duties effectively.
And sometimes common sense comes into it as well. I mean, I don't know whether the person that you're talking about would have been exposed to the potential danger. A big fact for us was my client and his family lived 10 miles away from the plant. The idea that he would willfully blind himself to the potential that this thing was going to blow up doesn't make a lot of sense. But then again, talking about the potential blow up wasn't really a great jury hooks.
I would echo the second part of what Alex said, which is, and you know, you said you already looked at it, so but I'll just finish the thought. You know, there's the went out and learned stuff, but also what did he do in discharging? So if he was diligent when he got a piece of information, when he got something that implicated a potential problem, did he immediately get on it? Did he assign somebody, or did he himself go check it or work on it? And it seems to me somebody has a track record of taking seriously and appropriately responding to actual, you know, red flags or anything like that. That doesn't seem like the kind of person who just, you know, wants to avoid learning things for the purpose of avoiding the law, or you know, a purpose that one would really think makes the person a bad person, deserving of prosecution.
Right. So the question was whether this issue is being applied differently in a safety/regulatory context than in the accounting securities fraud. I mean, I think in terms of I don't think the prosecutors are framing it any differently, but I do think it has a different effect. I mean, I think both in terms of, there are a couple things, and maybe this is not a lot different than accounting. Part of what happened in our case was there were all of these regulations, like that you just alluded to, about accuracy, about truthfulness in statements that set a fairly high bar, so that the government was able to say there were all these provisions that were being violated, and from that you can assume that these folks had a higher duty of care, and so there, that comes into play. I think as a jury matter, when you're dealing with issues of safety, jurors are much more willing to look at a should have done better type of theory. And I think, you know, in the event that you're taking these cases to trial, I think that really does present a dilemma. I mean, our client testified, and he was an earnest Midwestern Navy veteran. One of the things that he testified to was, as he looked back on his performance, he was ashamed of the mistakes he made, and he should have done better. Quite frankly, that, you know, even if we had decided that was bad testimony, he was going to give it anyway because he felt it very deeply. I'm sure there were some jurors who were sitting there thinking, why did he just say that? Now I got to convict him. It's something that I think you have to be very careful about, because when you're dealing with issues of safety, and my guess is you're going to see this in the BP stuff as it goes forward, right? There are going to be, I would bet, prosecutions based on what should have been done based on what these folks, you know, the accumulated knowledge, prosecutions coming out of this fast and furious. And part of the defense, I would bet, will be that, you know, to the extent that there were things that were out there, that the immediacy of the danger was not known, but in a regulatory and safety environment, it becomes a slippery slope. I don't know what you guys think about it.
Yeah. Well, I mean, one thing that we came across, I mean, and we were sort of aware of it going in, and I actually think that that jurors are equally willing to commit on a should have known, to convict on a should have known for, you know, financial fraud crimes. Especially, I mean, I guess as we get further away from, you know, the sort of very dramatic days of the, you know, financial crisis, maybe that starts to dissipate. But I mean, you know, the jurors just come into these cases like, you know, ready to hang people. I mean, so.
And I think in the financial fraud cases, there's also kind of a predisposition to be very dubious about somebody who says, I should have figured it out, but I didn't. I mean, there's a skepticism in these cases that may not always be there in the safety cases. Mm-hmm. John, did you have a question?
I was going to ask, you know, Tim talked about harmless error in your case with the Murray rule and how bad that is and what an incentive it is for judges to give the instruction. In Dan's case, you not only convinced the Second Circuit it was prejudicial error, but plain error. How'd you do that?
So before you answer, I mean, just so it's caught on the camera, John's question was about the harmless error rule that Tim and I were complaining about. He's asking Dan how, if we're bitching about harmless error, how Dan managed to win a plain error case.
I think, quite frankly, the fact that I've seen one definition of plain error, which is when the error, it's plain because every constituent at the trial has a duty to get it right. The defense counsel, the prosecution, and the judge. And so everybody is being held to task for not getting it right. With the conscious avoidance instruction, the Second Circuit has gone out and explicitly taken the extraordinary step of telling U.S. attorneys in 1988, give this to all of your criminal assistants. It's on you. You need to get this right. And we did object to. We were stating an objection to the conscious avoidance instruction, and that it was open to allowing the jury to find membership in the conspiracy because of conscious avoidance. And I didn't mention that before. Both the instructions we submitted and the government submitted had what would have been a legally sufficient conscious avoidance instruction. So it's a little it's a little confusing, I guess, or perplexing that the government, they knew what the right instruction was, and they saw the judge not give it. We were in the sort of ballpark, and they sat on their hands, and that just seems to be quite a bit of it should be a problem, I would think.
I can see how that takes care of the plainness part of plain error, but you also have to show prejudice.
Well,
and how do you show prejudice if there is sufficient evidence of actual knowledge?
Sure. Okay. Well, the prejudice was that that the jury could have convicted on the negligence standard because there was substantial evidence in the record that supported our theory. The court found that without the main cooperating witnesses, the documentary evidence supported both theories, so that should be reasonable doubt, and that the government cooperating witnesses had huge credibility problems when it had to plead guilty to perjury from before his pre-cooperation days. He was lying about certain things, and inside trading that ultimately tripped him up and gave him his prominent role in this case. I think it's that there was merit to our defense, and it was close enough. And therefore, we were prejudiced by giving the jury an out. Well, if you should have known.
Do you think it's in part because the only evidence of actual knowledge came from these cooperators who were so incredible?
Precisely.
Right. And so once you
Also,
took that away, like, you really did just have, well, we think what we did was right and we think what we did was wrong. And so they could have easily said, well, whether they knew at the time, they should have known.
Yeah, we don't have to resolve the tougher question. We can just say we can all agree that, well, at least he should have known.
Right.
So the question was whether there have been efforts to get judges to make rulings or prosecutors to commit at the beginning of trial to essentially what the instructions are going to be and what the theories of liability are going to be, to avoid this problem of getting blindsided with the instruction at the end of the case. Did that come up with any of you guys in your cases?
It didn't, because we were blindsided. To me, that strikes me as if you can do it, great, and why not try? But our judge, he one of the reasons he wouldn't write out the instructions is because he wanted to react to what was said in the closing arguments. You never know when you might have to give an instruction about something else, and if he's already given you the instructions he's going to give, he can't very well do that. So I think it's they should be tailored to the evidence as it came in, and to constrain that up front. Strikes me as was unusual, but
I do think that given the case law that's out there, it would be a very smart move.
Yeah.
It's one way to start locking in your prejudice, and to the extent that with Mari and similar cases, the battleground is going to be on getting around this harmless error rule. The more you can start documenting how you would have done things differently, the more likely you are going to be able to prevail on that. I do think it's interesting, though. You look at Dan's case, and literally, this was a judge's idea. The government was pretty happy to hear about it. But it wasn't even a situation where the prosecutors were pushing it or had tailored their theory to it. So, but, I think this is a doctrine that's developing, and it happened with honest services, too, that there was more and more litigation before the trial about, trying to force the prosecutors to say what their theory was going to be so you could defend against it. Tim, I'm sorry.
Oh, no, case has that ever been done before? saying an entire country is corrupt and you should have known about it, and since you're doing business there, you must have known this, you must have read the State Department's latest corruption reports or whatever. And if that hasn't been done, I mean, what's the precedent? I mean, you know, where does that go from there? It seems like.
I think John and I talked about this earlier today about where it goes from there, and it seems like it could go all the way to strict liability. That basically, you can't do business in a country if it's sort of known that it's a corrupt place, and.
I was thinking, like, what about Chicago? No, I'm serious.
Yes,
like,
Patrick Fitzgerald.
You know, taken to the logical extreme, right? I mean, there's corruption problems in lots of countries. Afghanistan, where contractors are making a hell of a lot of money, and there's big time corruption problems there.
That's the problem, is that the expansion of the doctrine and the instruction. It's just
But one
there is
thing,
no logic.
did you all have, I mean, this is part of the reason, that we see a lot of our clients now having FCPA audits, and there's a funny name for a company that you're selling something to, and all of a sudden, teams of us are going over there and interviewing and making sure people aren't, and frankly, it's a smart move to avoid, an FCPA conviction on a conscious avoidance. You hear a funny name for a company, you turned a blind eye, you didn't, pay $1 million to do a full-blown investigation. But probably you guys were too, the timing was before, it would be interesting to see in subsequent prosecutions the extent to which the defense uses, the fact that they did FCPA internal investigations, that they had FCPA audit practices as a way of saying we weren't turning a blind eye.
Well, for a company, that would be helpful. Go ahead.
I was just going to say, 'cause this is something else we were talking about, but the problem with that is, it is then used as evidence by the
That
government.
you knew,
That
you were
you were aware
suspicious.
of a high
High
probability.
probability.
Right.
The more you do to inquire, the more it suggests that you're aware of a high
Yeah.
probability. It's a catch-22.
But if you're going to be dinged with the high probability just, because you are doing,
But
Right through it.
we had an example in our case. There was a tape that Burke's lawyers produced of a conversation they had with him while this investment was going on, in which he is asking them basically, I don't know what Kazini is doing. He's half a world away.
Right.
How do I protect myself if he's bribing somebody? That's used as evidence of awareness of a high probability.
right.
And the protection would be, how do I keep it away from me?
How do you protect yourself?
No, I'm sure he's
Yeah.
trying to
And so if you've got a company over, in Afghanistan or
Right.
Azerbaijan or any of those other aid countries that has corruption problems, the fact that you're asking the questions,
Right.
our case would suggest.
It's a bad thing. But we know these companies are going to do it. I mean, companies can't afford to even be indicted, and so they're going to continue to do these investigations. So the question is, will it end up? Is there a way that we can figure out how to, take it out of the realm of, well, that proves that you were suspicious, and into the realm of, yeah, we didn't turn a blind eye. We actually, because again, that's an important element that often gets overlooked. But they have to show that deliberate ignorance. So.
Our prosecutor even argued that our client was turning a blind eye by hiring a Detroit lawyer and not a New York lawyer to do the due diligence.
And stereotypes like that?
Yeah.
Let me ask you this: in your case, the error in your case, did it involve a bad jury instruction as opposed to? Your argument was, or the plain error argument was, this willful blindness instruction shouldn't be given, rather than the argument in cases like Andy's and mine, and I think in a lot of ours, which was no willful blindness instruction. I think that's, to me, that's a big difference between cases that win and cases that don't. Is where you're attacking the language of the instruction, you got a much better chance of winning because you do get a different harmless error review than if you're saying no instruction at all.
I think that's right, and we argued that in the Rule 29 motion. There was no predicate, but we didn't push that on appeal.
That answer was given in response to a question about whether the error in Kaiser was the giving of a wrongfully worded instruction versus the giving of an instruction without an evidentiary predicate.
And I guess just the follow-up is, do you guys have thoughts on, what sort of things you might want to do in order to try and push, if you're going to get a willful blindness instruction, any thoughts on how you might make it as good a willful blindness instruction as possible?
Tim's question is how to make the willful blindness instruction better if you know it's coming. Alex, I know that was an issue in your guys' case. You guys worked with the instruction and actually improved the language, right?
Yeah, we were able to improve it in terms of reminding the jury, that the deliberate ignorance concept applied only to, this element and not to another element. What else did we get in the original?
That was the main thing, and I will say that the reason why we were able to force the judge to move on that one, because he, when we started presenting this argument immediately, was like, what is your problem with my instruction? I don't want to be giving for 20 years.
Right.
And the only reason we were able to get him to move even on that point was because we had a direct Fourth Circuit site that said, like, this is the instruction
Yeah.
you should give it, and this is an important distinction. I was like, fine, I'll add that.
Yeah, and there's a lot of good language in the, judges, if you can put quotes around it and follow it with an F-3rd site, judges are much more willing to, say something in their instructions, and as Andy said a couple times, the appellate courts are really wary of this instruction and should rarely be given, and they, talk about, like, perhaps exploiting this point that I mentioned earlier where the Fourth Circuit has said, a finding of deliberate ignorance based on circumstantial versus direct evidence, maybe there's some way to work that into an instruction. I'm not sure, given that, typically the law treats the two types of evidence the same, but in the Fourth Circuit is sort of differentiating between them in this particular area, rightly so, I think. But
I would think a stronger, a fairer, show my bias, a conscious avoidance instruction would make clear that it's a subjective standard that the defendant had to actually know. I would work with the circumstantial versus direct, and try to see if we can get the for the conscious avoidance part, it has to be direct evidence, but the high probability. So not direct evidence of the fact, but direct evidence of the high probability. So it's so you don't sort of have an attenuated circumstantial evidence of circumstantial evidence.
Right.
I think those would sort of help it and get the judge to stress it has to be a high probability.
And say it just like that.
Once more with feeling.
You know what I mean? Just really
I-
double underline and bold.
And I do think that, like with most instructional issues, one of the other things that is important is putting the language we like in the instruction in plain English. The point about what is negligence is a good point. What does subjective mean? We speak in this language all the time. I don't think juries do, and so it has very little meaning. So the more that you can get judges to be instructing juries in terms that they understand, the better. From some of these cases, especially some of the cases that you guys cited in your brief, judges should not be reluctant to say to a jury, you may not convict because you think he should have known.
Right.
That is the law.
Right.
To the extent that the instructions are designed to tell the jury what the law is, that's the law. So, could have, would have, should have. But I think that's a good question. So we've run over time, so I wanted to thank our panel and thank all of you all. I hope this was instructive.